Welcome to the Migrant Center for Human Rights DreamWeek podcast series on advocating for equality and justice for immigrants under the Biden administration. My name is Sarah Ramey, and I'm an immigration attorney and the executive director at the Migrant Center for Human Rights, where we provide free and low-cost legal services to immigrants at the South Texas Detention Complex. We present this program to you today as we welcome a new administration, as a call to President Biden and Congress to not forget to take common sense action to align our internal enforcement policies with our American values. A list of topics for today's podcast can be found in the description box. If you missed our podcast on asylum policy, border policy, or detention policy, we encourage you to listen to the recording on our YouTube channel. Many of these issues are interconnected and overlap. We also encourage you to tune in to our last podcast in this series tomorrow at 8:30 a.m. Central Standard Time. Today's podcast is intended to provide an overview of the issues surrounding interior enforcement, and will suggest several ideas on how President Biden and Congress can address these issues. It is our hope that you will feel encouraged to take action in the democratic process of making our nation a good place for immigrants. We'd like to begin our podcast today by talking about the enforcement actions that have taken place under the Trump administration. So we've seen a number of raids, some larger raids, some periods of time when there have been more raids than others. And then we've seen what we're terming stakeouts. So that's where ICE basically follows someone, waits for them, and arrests them. With regards to raids, one of the main problems with raids is that ICE will pick up anyone in that vicinity. So, for example, if ICE is looking for what they term an alien fugitive, someone who has missed an appointment, or someone who is out on parole in a criminal matter, and they decide to pick them up and put them through the deportation process, they will often go to individuals' homes, and there could be 4 or 5 different immigrants sharing a living space. If those other immigrants do not have documents, ICE asks them for IDs. They don't know that they don't have to respond to questions, and they'll all end up getting picked up and thrown into detention. The other situation that we see is where ICE will go into workplaces such as factories that have a large immigrant population, and isn't targeting necessarily the employers who are violating law by hiring individuals who are undocumented, but is it targeting the immigrants? And there isn't a law really against working, even if you don't have authorization. But of course, if someone does have legal status, then they can be kicked out of the country unless they're able to find some relief from deportation through our legal system. So, the issue of raids is still a concern, and we're encouraging the Biden administration to, come up with a policy that's going to, be more humane than we've seen in the past, and really not put people, tear them away from their families and their communities, and put them in this detention system and this court processing system, unless there's a really clear, public interest to do so. So where someone may have an assault conviction or something like that. So turning to safe spaces. Okay, ICE typically will not arrest people at schools. They do stake out hospitals, and they will take people to hospitals and then sort of sit and watch them the whole time they're there getting treatment until they can drag them back to detention centers. Sometimes people have been shackled to hospital beds. So, this is really concerning. You can imagine the stress and anxiety somebody would have in this situation, which can inhibit their ability to, go through surgery effectively and heal. In addition to the emotional sort of trauma related to that. And then we're also been seeing a lot more courthouse arrests. And we highly encourage listeners to read our op-ed on this issue. We want the Biden administration to come out with, as soon as possible, this could be a week one priority, a statement saying that individuals will not be arrested when they go to court. We need to make sure that people, whether they have a minor or a slightly larger issue to deal with in our court system, we need them to feel like they can get that resolved, right? Whether it's a criminal or civil matter. We also need the court spaces to be safe for victims of domestic violence and witnesses, right? Not only for witnesses who are victims of domestic violence, but for any case. If we don't have those witnesses, right, we're not going to be able to obtain convictions, and basically our justice system and our ability to protect our communities is going to be significantly undermined. So we would like to have a very clear policy memo in this regards, right from the beginning of the Trump administration, to send a clear signal that we're going to be following legal processes and common sense, humane processes. The other place that's been considered a safe space is church. There are immigrants with final orders of removal have taken sanctuary in churches who have been there in some cases for a couple of years, and ICE has tended to respect church spaces. That is something that doesn't need as much advocacy, but has arisen in conversation in the last few years because the administration has come back and sort of tried to slap these really, really high fines on individuals in these situations. So we're talking about fines, upwards of 6 figures for basically not reporting for deportation. And there's a lawsuit that was recently filed to challenge these fines. And of course, the administration could cancel them. And that would be a pretty quick administrative action to, again, send a signal that people aren't going to be penalized when they have no criminal history, per se. The, issue with this is obvious the government's not going to get this money, right? They're not probably going to get a cent of the money. Maybe if it were $1,000 fine, the church community would chip in and, pay it for them. But, these aren't individuals who are working, right? They can't really get out of the church space. So it's just really meant to be a punitive measure and to send a signal more than anything. And it's part of the overall negative tone that the previous administration has taken that can be changed. Many local jurisdictions around the United States have some form of cooperation with ICE. We'll look at 3 of these programs today. First, ICE Detainers. These are requests by ICE to hold for up to 48 hours individuals in the custody of local law enforcement after the time that they would normally be released. Many courts around the country have found ICE detainers to be illegal, as states and local jurisdictions do not have power under any statute to continue to hold someone once a judge has ordered their release or once their sentence has been completed. Second, Secure Communities is a program whereby local law enforcement will send fingerprints to ICE to run through the DHS database. The problem with Secure Communities is that individuals who have simply entered custody and eventually may never even be charged with a crime formally, including individuals who are charged with the crime but are ultimately found innocent, and individuals who are convicted of minor crimes. Everybody who passes through local law enforcement's hands will have their information turned over to ICE. So this, along with ICE detainers, makes a lot of people with really no criminal history wrapped up and placed into a deportation pipeline. One of the biggest problems with these programs is that they make local community members afraid to report crimes to ICE, and that makes all of us less safe. Another problem is that some of these programs result in racial profiling, as law enforcement officers seek out individuals who may not have documentations in the United States. So that means not only are they going to be targeting immigrants, but anyone, any American citizens who may look like they are Hispanic or from another part of the world. The third program that we want to mention is the 287G program. This program deputizes local law enforcement officers to act as federal immigration agents. So this gives them the authority under federal law to detain someone, just as if they were an ICE officer. This program, at last count, had a budget of about $24 million. That's the funding that ICE uses to train and process these contracts. Many individuals opposed to 287G programs, in addition to complaints about eroding the trust between law enforcement and the community and racial profiling, don't like this program because the states or the local jurisdictions will actually need to foot a significant amount of the overall costs of running these programs. 126 of these agreements were signed by the Trump administration, and we currently have 148. So 22 of those agreements were signed prior to the Trump administration. We have here a link to a toolkit for advocating with local jurisdictions. If your jurisdiction does have a 287G program, you can use these tools to convince the local sheriff or other decision makers that they should withdraw from the 287G program. In fact, 28 jurisdictions have ended their contracts for some of the reasons that we mentioned. There's also a link here to a map of what jurisdictions around the country currently have 287G policies in place. Now, on the flip side of jurisdictions that are looking to increase their cooperation with ICE, there are jurisdictions that are doing things, are passing laws to protect immigrants. So we'd like to briefly mention the federal harboring statute under 18 U.S.C. 1324. It is a federal crime to, knowing that an individual is undocumented, conceal, harbor, or shield them from detection. So there have been allegations in the last few years that individuals who are protecting, perhaps by providing shelter or residence to undocumented immigrants, are committing a federal crime. However, at least one court, that being the Fifth Circuit, has ruled that unless there's an element of concealing or shielding or preventing ICE from executing their federal law enforcement responsibilities, the individual is not being harbored. So an undocumented immigrant can live in an apartment complex and the landlord will not have any issues unless ICE comes in and has the proper warrant and legal papers in order, and they actively prevent them from entering. Turning to sanctuary jurisdictions, the question here is when, how, where to cooperate with ICE. We have an op-ed if you are interested in getting more information on this point that basically discusses the danger to overall community safety when local law enforcement works with ICE. And this is really when there are policies that are widespread that are going to cast that net too broadly and turn over to ICE individuals who have committed minor crimes as well as those who have committed federal felonies like murder and rape. The Texas police chiefs of 6 major cities wrote a letter in support of SB 4, and that's the Texas legislation, which we'll talk about on the next slide, that basically says jurisdictions can be penalized for enacting sanctuary policies. And all of these sheriffs came out and said, no, it's really important in our community. We know from on the ground contact with the communities we serve that this SB 4 policy is going to be problematic, that we do need to have some type of sanctuary policies in place so that we can do our jobs effectively. It's really important to keep in mind that whenever we talk about sanctuary jurisdictions, we really are using a term that is in no way accurate. Sanctuary jurisdictions do not give amnesty to immigrants. ICE still can carry out raids and arrests in sanctuary jurisdictions. It doesn't limit the federal government's authority. It simply says that the local law enforcement doesn't have the need or really the interest in assisting ICE in doing their job. The problem is both that it's created this backlash in the more conservative and moderate communities against these policies. And on the flip side, when immigrants hear sanctuary jurisdiction, they feel incorrectly that means that they will be safe. And as we just mentioned, ICE continues to pick people up. There, at one period in time under the Trump administration, there were a number of raids that were taking place in Austin. It was about 2 years ago, while Austin effectively had a sanctuary policy in place. So this is common parlance to use because it's more or less understood what is meant. We don't have a better term, but it really should come with that caveat that people understand what's really at play so that there's not misinformation and the resulting harm by being uncautious in these circumstances. The other issue is that even jurisdictions that have decided to retract their cooperation with ICE have not done so 100%, right? So even the California law, which we'll talk about next slide, it has 800 different crimes that if you commit, you will be turned over to ICE. And so this policy in every case that we've seen, it is not 100% sanctuary, even with local law enforcement, right? It never is with ICE, and in certain cases it won't be with local law enforcement either. So the question becomes, who has the power to set local policing policy? The 10th Amendment to the Constitution basically says that any powers not specifically reserved to the federal government or directly prohibited rest with the states. And that means that states, not the federal government, have policing power in their jurisdictions. So this means that the state, is the ultimate deciding force. Not the federal government, also not the local jurisdiction. So we've had a number of local communities such as Orange County in Southern California that have tried to enact sort of anti-sanctuary legislation, and that's been struck down by the courts. Why is that? Because there's this concept of home rule. So basically, if the state directly delegates to a local community their policing power, then that local community can make those decisions. But if such a delegation by the state has not been done, the local community's policing decisions are sort of overcome or less powerful than what the state wants. And we see this in two different cases, as we'll compare. Texas and California have both put forward legislation. Texas with SB 4 in May of 2017, and California in October of 2017. And the Texas legislation, it says several things, right? It insulates from prosecution or dismissal any law enforcement agent who decides to check for immigration status when they're making an arrest, for example, not coming to complete stop at a stop sign. They can ask if that person is documented and not lose their job or be prosecuted. So there were local policies that were being put in place by cities to prohibit that, and then SB 4 came along and basically wiped those all off the board. SB 4 also allows for criminal or civil litigation against jurisdictions and officials with sanctuary policies in place. And then lastly, SB 4 set out to penalize public officials for speaking in favor of sanctuary policies. The Fifth Circuit Court of Appeals found that the state has the authority to set this policy with regards to policing. The only section of the SB 4 they struck down was the First Amendment constitutional right claim on public officials being able to speak their minds in terms of their position on sanctuary policies. The California law, SB 54, it is completely different in what it tries to achieve, right? It prohibits local law enforcement officials from asking about and arresting based on immigration status, halts the use of ICE detainers, limits immigration enforcement at schools, hospitals, and courthouses, but it does still allow ICE to interview people held in custody, right? So California doesn't run afoul of the harboring provisions, and it allows reporting of ICE to ICE of any immigrant with an actual conviction. So not just someone who's going through the court process, right, innocent until proven guilty, but someone with a conviction for one of these many crimes. So at the end of the day, the California law is currently in force. The Trump administration sued, but it's currently active because the courts have said policing power rests with California. A poll was conducted shortly after SB 54 was signed, showing that the vast majority of Californians, 53% versus 29%, support this legislation. I'm not aware of any poll that's been done in Texas to see if public opinion in Texas is different, but it is worth keeping in mind that it is sometimes politicians putting these policies in place, not necessarily community members who are seeking these policies. So what drives enforcement? It's a tone, a idea that we need to be tough on crime even when immigrants are not criminals. It's that detention facilities are largely privately run, and they have a very well-paid lobby group in Washington. And the two main groups are Geo Group and Core Civic, but there are other players. ICE does run some of its own facilities, and in my experience, the facilities run by ICE are typically better. Not in the sense of the individuals working there, but in the sense of access to counsel and services that are available to individuals. The problem is that when for-profit companies are running detention centers, they have an incentive to cut corners, to spend less on food, to spend less on staffing. So at the facility we work with, we've talked to some of the guards in the past, and they've cut down the number of people that are staffed to bring detained immigrants to meet with us. So the wait time would get longer as a result. And part of the problem with this is that we have a detention bed quota. So Congress has set a certain amount of funding to be given every year for those beds. And so there's an incentive to fill the beds, right, instead of just paying for empty space. This really doesn't make sense because, of course, we should only be detaining people if we need to detain them. We should not be taking away someone's liberty without due process of law with a clear justification. And we encourage you to listen to our detention policy podcast for sort of more discussion on detention policy. But broadly speaking, the Bureau of Prisons has actually said that all private companies that have contracts with the government, those contracts will be phased out so that there will be no private prison group running in any of these federal facilities. So that's in the non-immigration context. But if our federal government has determined that it is through various studies, right, the prison system when run by for-profit companies is not as good in terms of the basic amenities, right, the basic food. I mean, amenities isn't really even the correct word, right? The food, the medical care, all of that, then it only makes sense for the federal government to transfer that policy to the immigration detention context. And so we are encouraging people to talk to your elected representatives, put pressure on the administration through media, whether that be social media or working with your local newspapers and television stations, radio stations, get the word out and keep up the pressure, right? Because if people feel that these are issues that are of kind of a lasting concern, right, then they'll pay more attention. So that's both the higher ups, but also the people who are in the administration working their day-to-day desk jobs, that are having conversations around these topics. If they feel like there's a big issue that comes up in the news and everyone's talking about it because it's popular at that point in time, and then there's no sustained interest shown, it can fall off the news cycle, right? It can fall off of people's radar and just get buried under a stack of papers on someone's desk. So deprivatizing detention, huge, right? It'll take away one of the driving forces for interior enforcement, as well as higher numbers of detention at the border. And Congress specifically has power over the detention bed quota and funding. So there are several different places where community members can reach out. We would like to spend a brief moment before we wrap up today on alternatives to detention. So number one, bond is often set in cases minimum $1,500, and it can go up to however high ICE or the court wants to set. So we often see around $7,000, $8,000. This depends on detention facility, but typically is going to be somewhere between the $5,000 and $10,000 range. The statute that gives authority to the government to release someone on bond also gives them the authority to release them on what's called conditional parole. That's where the individual doesn't have to pay a bond to be released. And this is really important because some individuals don't have money, right? And only certain areas in the country require that judges take into account an individual's ability to pay. So, specifically on the West Coast under the Hernandez litigation. And it also allows for more flexibility in terms of setting up a plan that's going to help ensure that person come to court. So for example, a judge could set parole for an asylum seeker with the condition that they participate in the case management program so that they would have a social worker support person assigned to them to help inform them how to get to their court hearings and attend their ICE check-ins and all that. There's a whole toolbox that ICE has in addition to conditional parole. The judge does not have this authority, but ICE does. And to some degree, and with regards to some of this, USCIS also has authority. So for example, deferred action. Okay, everybody knows about DACA. DACA is one form of deferred action. Deferred action exists sort of outside of DACA, and that authority was used to create the Deferred Action for Childhood Arrivals program. So deferred action can be granted by USCIS, just like with DACA, but it can also be granted by ICE. And this comes with the right to have a work permit. There are also options for releasing someone for humanitarian reasons. So this is usually medical. It can also be, if an individual is pregnant, or there's other sort of factors which could involve something like family reunification for purposes of, testifying in a certain jurisdiction, etc. And then also public interest parole. And these two often overlap, right? Because it is in the public interest to act on humanitarian cases. So these are a lot of the cases that we do at the Migrant Center related to asylum seekers who have passed credible fear interviews. There is a memo specifically on this issue saying I should grant in the public interest because we have an interest in upholding our asylum laws and giving people protection and the right to seek asylum here in a way that's supportive to that process. So not where they're locked up and they have a difficulty finding counsel and getting evidence. So individuals can be released on their own recognizance, right? This is basically parole in one form or another, or an order of supervision. And that would be ICE check-ins every month, every 3 months, more spaced out as the person continues to comply. It could include being released on an ankle monitor provided by ICE. And it's worth noting that there are private companies that sort of serve as guarantors that someone's going to pay their bond. That's different, right? So that person has been granted a bond, a company pays that bond, and they effectively, directly or with a partner, will place that person on an ankle monitor, and that person's paying additionally for the ankle monitor program so that they can borrow the money to pay the bond. Thank you for tuning in today. Please come back tomorrow at 8:30 a.m. Central Standard Time for the last podcast in this series. We will be discussing affirmative benefits, including DACA, TPS, and citizenship, and discussing President Biden's proposed legislation addressing these issues. Visit us on our website at migrantcenter.org to learn more about important news items in the immigration field, legal analysis, as well as job and volunteer opportunities and other information about the work that the Migrant Center carries out at the South Texas Detention Complex. If you would like to sign up for our newsletter, you can email us through our website or using the address provided on this slide, admin@migrantcenter.org. Thank you again for tuning in today and have a wonderful afternoon.